All right, welcome to the Hive Live, everyone. If you are here in person, awesome, good job. We're going to go to a Q&A after the presentation. It's not really a presentation, but we'll get to that in a minute. If you are watching on YouTube, be sure to go to the reagenthive.com, register to get on the live, get all the resources and whatnot. It's not spam. You just get notifications when there's a Hive Live coming, what it's all about. So we're just here to just collaborate, learn from each other. We have really high level agents that come on and do give talks and stuff like that. I'm going to talk about probate and estate owned properties today. So bear with me if you're expecting somebody super high level, maybe not. We'll go, but I do have some experience with probate properties. Matter of fact, I just got one under contract this morning, or actually last night we went under contract. So, and it was quite a process. So I can definitely talk about that, talk about other experiences, and I'm gonna dig in. So I have some slides, but let's keep it casual. If y'all have a question, just unmute. Definitely get a cash offer. Get the cash offers ready, Josh. Yeah, we'll talk about investing in a little bit for sure. But yeah, as we go through the slides, if you have a question, just let me know. Keep it loose. We'll definitely get into it more. We'll turn the recording off and go. Let me find my slides. Bear with me one moment. Let me get my slides open up here.
I love houses in probate, TJ. I make cash offers on those things for days. I'm just throwing that out there for you.
I know you do.
If your client decides that that's what they want, I got you.
Sounds good. Okay, here's my slides. Let's go. Slideshow. Okay, can everybody see the slideshow? Of course, I am on the wrong slide to start off with. You can tell I'm very prepared today for this. Here we go. Okay. So, like I said, can everybody see the slides? Thumbs up. Good. Okay, cool. Awesome. So, working with probate and estate-owned properties, this is just going to be like a surface level, kind of like entry level, if you will. We're definitely going to talk about some really the most important things that I think are really need to be talked about when you're thinking about whether this might be a good niche for you or not. I can tell you the one thing that I wish someone had told me when I started getting into it is that these leads typically take a very long time to convert into a transaction. That's maybe the downside. Some people might think it's a downside. If you have your pipeline going, you won't really miss a beat, and just all your pipeline leads just take a little bit longer, but hopefully you have some to kind of fill in those gaps and you just keep it rolling. The plus side to it, it's just so gratifying, and these clients are probably have trusted me and my guidance the most out of any other clients that I've really had. So they definitely rely on you. It's oftentimes kind of it's an overwhelming thing. The family dynamics are a real thing you have to contend with. So that's like, you have to have a really servant heart, patience, and understanding that you can't get too involved between the family dynamics, but you definitely have to manage family dynamics at some point, especially when there's more than if there's like 3 or 4 siblings. There's always one sibling that is like the wild card. So put that out there for you. It happens every single time. All right, so let's keep going on. A couple things to start off. So what is probate? So probate is just the legal process of when somebody dies that they validate the will and kind of give permission to the family to go ahead and settle the estate, whatever that looks like. It's always more than just a home in an estate. There's bank accounts, there's stocks, maybe there's retirement accounts, there's checking accounts, all sorts of stuff that you can think of, any kind of asset. There's debts also that need to be settled. One of the obvious ones is if there's a mortgage still on the home, of course that has to be settled. So oftentimes a family has to sell the home in order to pay off the outstanding debts. Or if they don't sell the home, it has to be at least transferred to a living family member or a trust, or all that. We can get into that after, but it can't stay in the deceased name, because it could, If nobody does anything, the home will just sit in the deceased name. And I've seen that happen where multiple generations have lived in a home and they just never went through the probate or administrative process, and then that causes quite a bit of hassle for the family members down the road because you got to go back several generations to and basically probate each one to get down to where you are now, so you can go ahead and sell and convey the property. So testate is a term you'll hear if you start doing probates or estate sales, excuse me, which all that means is that there is a will. The person that died had a will in place. They've named an executor and they've have directives about what they want to do with all their properties and assets. Intestate is a term referred to when somebody passes without a will. The difference with these two, if you have a will, you set up your will, then you are in control, and your executor is in control of the estate and what happens with the estate and a lot of the decisions that are made. When you don't have a will, if you're intestate, then the state, in this instance, the state of Georgia, whatever state you're in, they're all very similar. The state is what controls what happens to the assets and all that stuff. Now, there's laws, so they're not just going to go give it to their buddy, but there's laws that govern that. However, if you've ever, tried to get your driver's license renewed, or if you ever dealt with the government, it can be a little bit of a delayed process, and sometimes you don't get the answers really that you're looking for in all that quickly. So, any questions about testate versus intestate?
DJ, I'll just add one thing. As we just went through it on a property down in Warner Robins, where if a family member passes away and they have a will, but some time has passed before the sale and they no longer can produce a copy of the will, it still is treated as intestate as well, because they can
yes,
a copy of it.
That's a very good point. Yes, it has to. So you have to have the will. It has to be witnessed properly. There's a lot of stuff that that really needs to kind of align. Now, this is what I recommend too with your clients. If you have closing attorneys and they also do estate planning, or i.e. do wills for people, that's pretty good. If you do like I'll do events that where I teach people, or actually I don't teach. I bring in the attorney and they teach about estate planning and what that means. I highly recommend, if you have people and they're considering that, or maybe they inherited something and they have they have this big chunk of money and they're not sure what to do with it, so they want to do an estate plan so that they don't go through, or their heirs don't go through what they're going through. That happens quite a bit. Just make sure that you advise them. You can't advise them legally, obviously, because we're not attorneys. But I would point them and guide them in the direction of using an attorney that has done this before, not LegalZoom or onlinewills.com. Like, that's not, they aren't really set up for, they can be contested a lot of times. They're not like solid wills, and they often aren't even really valid, or they don't protect the assets in the family like they really should. It's just like a generic cookie cutter kind of wills that those things will have. So that's a good point, Dakota. Thanks. All right, let's keep moving on. So key players in every probate transaction: the executor or personal representative. Let me back up a little bit. I think there's a slide about this, but I want to talk about this. If there is no will, then you have to petition the county to start administration of the assets or of the estate. So typically you have to get all the heirs have to agree on one particular person that is going to be the administrator of the will. If they can't all agree, then the state decides they might appoint a public administrator to administrate the will, or the court will basically decide like who's going to be the one person that is responsible for making sure the estate is taken care of and closed out. When there is a will, it's called an executor. Executrix, you might hear. It's like male, female. I just call everybody executor. Executrix sounds kind of weird. I don't know. But that's an executor is the person that was named in the will to go ahead and do the whole probate process and administer the estate. the certain things they have to do is they have to they have to open a bank account. So they have to get an EIN number, a tax number, because you're basically starting an entity, and anything that's sold from the estate has to go into this bank account. And it has to be very well taken care of, very well kept track of. A lot of times executors put their own money into paying bills and keeping the electrical on and all that. So that also has to be kept track of, or things like that can be paid from the estate's account. But like I said, they're just got to keep track of everything, it's like another job. Sometimes I've heard a lot of executors say, like, I had no idea this was like another job that I had to do, because you have to be very kind of detailed oriented and organized. So that's one of the first people. Probate court is, of course, the county that everything has to go through. It's a lot easier and a lot faster if you have a will, as opposed to not having a will. And also it depends on how quickly things will happen by county. So for instance, Fayette County, where I am, very quick, very easy, especially if you have an attorney that is familiar with the process. It goes by, you're talking about a couple weeks, but from the time they send in the petition, for the time they get the approval to go ahead and start selling assets and things like that. I had one in Clayton County last year. It took a full year. I'm sorry, it was Fulton County last year. It took a full year before that did not have a will in that case. So it made it a little bit longer. And then Fulton County, like, system got hacked, and their computer systems were like shut down for like a week. I don't know if anybody remembers that, like last year or the year before. Anyways, that's my troubles and tribulations, but they're a little bit slow. So it depends on the county. That's why it's important to really understand and get to know. You can go down to the probate office and ask them a ton of questions. Usually they're very friendly, and just say, hey, I'm working with more and more families that are going through this probate or administration of an estate. What can you tell me about, how can I help them? How can I serve them better? And typically they'll get into a conversation. They'll give you some pointers about what their role is, and how you can interact with the probate court. I rarely interact with the court because there's always an attorney typically doing it, and plus you can't really do anything. You can't sign any papers. You can't submit anything. It has come from the family or the executor. But it's good to know exactly the process and how it works. Attorney, of course, legal counsel. I highly recommend that. Some people have done it themselves. There's always something that pops up that's unexpected. And when you're helping somebody that doesn't have an attorney and they're trying to go through probate, they start to use you as like their legal advice. So you just have to be very careful in that instance, and keep saying, like, listen, I can't give you any legal advice. I can help you with the transaction. We can get this thing listed and marketed. It's going to be great. I can give you a little bit of guidance, but I can't give you legal advice. Heirs and beneficiaries obviously is the family. I had one last year where it was a guy had passed in his house. He had inherited that house from his parents. That probate was all set and all done. He had 5 children, each with a different mom, and one of the children had passed, and that child had 2 kids of their own. There was no will, so it was administration. It was kind of a nightmare trying to get everybody like on the same page. And then when you have minors involved as heirs in an administration, they do what's called I'm drawing a blank on the word, but they basically assign somebody from the state to be the advocate for the minors to make sure that they're not getting taken advantage of, and then that they're getting their fair share essentially of what happens. So it's another step where they have to review everything that's going on, and then before you can get any kind of approval to sell anything. So that's kind of a lot. Any questions so far? I know this is riveting. It's riveting information. Good. Okay. Moving on. Alrighty. There's so letters testamentary and letters of administration. You can imagine letters testamentary is what an executor gets once the county approves them as the executor, and they gives them the approval to go and sell assets and settle the estate. Letters of administration is just what they call it when there's no will, and an administrator is assigned to the estate. That's pretty simply all it is. Once you get letters testamentary or once you get letters administration, the way that you and I would operate is essentially the same. It's really not a difference from our standpoint. It's more of a difference of from the family standpoint of how it's how things are getting approved and how things are being pushed through the courts and the county and all that. Any questions on that? I don't want to gloss over it, but all right, no questions. Super cool. So just real quick, this is kind of the process, the steps. So you file the will for petition or file for administration. The court appoints an executor or an administrator. You'll see this a lot as you start to dig into this world. Inventory and appraisal. They say that the executor is supposed to make a list of all the assets, all the collectibles, all the things that are worth any money, cars, tools, things like that, and then put a value next to it. That is when an executor hears that, they're like, there's no way I can go through this whole house and put a price on everything. They don't really have to do that, especially if there's enough stuff in the home, you get an estate sale company to come in, and that's basically what they do. They put a value on everything and they sell it off, and then all the money from the estate sale goes into the estate's account. And then we kind of go from there. Now, if some homes don't have enough things for an estate sale to make sense, an estate sale company won't really help out because there's not enough. There's no meat on the bone there. Most of the time, like families will decide amongst themselves, like who gets what, like who gets the. Like one family I worked with, there was a grandfather clock in the living room, and one of the grandchildren was getting it, so they took that out before the estate sale. The family kind of goes in and takes what they want prior to an estate sale. That's okay as long as everybody's on the same page and everybody's getting along. And it's not like if you're talking about like a classic Ferrari that's worth $200,000, then that's a different story that needs to be appraised and that needs to go through the proper channels. But when you're talking about a couple $100, it's not that big of a deal. Notify creditors. So that's a process that people don't think of a lot. You still have to put things in a paper. You have to put an ad in a paper, believe it or not, in today's day and age. And then these credit companies they monitor a bunch of the papers where these notices go. And then they have it depends on whether it's administration or if it's a will, but it's about 4 weeks and it might vary from state to state. It's about 4 weeks that you have to run an ad, or that's 2 weeks you have to run an ad, and it's 4 weeks a creditor has to reach out to you and say, hey, there's a lien, or this estate owes me some money, and then go from there. And once you're past that, then then after you can still sell the home prior to that happening, or while that's happening, the executor just can't disperse the inheritance to the heirs until that's kind of settled. And then settle debts, distribute assets, and then close the estate. That's an important step that a lot of people forget, like when everything's done. So the estate is closed, probably could take a few months after your job is done and the house is sold. I usually will send an email, 6 months later, that just says, hey, how did things go? Were you able to close the estate? Okay. Just to remind them that it's a good idea to go ahead and take that final step and close it all out, shut the bank account down. That way if it's open, then there's a chance if another heir shows up out of the blue and says they have a claim, then things get a little squirrely when that happens.
How are they signing? As far as our documents go, because
Good
the
question.
house, they've gotten their letters of testament, they've got what they need.
Mhm.
How are they signing it? Because obviously the dead guy is still on the house.
Right.
So
Mhm.
do you say is there an official title? Obviously, check with the attorney, but is there a standard for getting that listing agreement signed?
If there's any question, just check with the closing attorney of how they want it. Oftentimes the closing attorney doesn't come into play until after after your binding.
Oh,
So,
I just mean the attorney that's handling the will.
Oh, as far as signing the will,
Like,
you
that's
mean?
what I mean. Like, do they sign like Bill Smith, the executor for, you know what I mean? What
Yes.
is the formal way they need to
Yes.
sign that listing agreement so that it holds up?
You,
And
yeah, you can do it a couple different ways. What I do is I put for the name where it's like printed, I write the estate of John Doe or the estate of John and Sally Doe. And then where the signature for whoever the executor or the administrator is signing, I will write, or they'll sign, and I put it all through AuthentiSign, so it's all there. Billy Smith, comma, executor for the estate of John Doe.
okay.
Yeah. So, and that I don't think that any attorney would have a problem with that during the closing or any, when you're filing, recording the sale or anything like that. Covers just about everything. The trouble with that is when they sit down at the table and they're doing any wet signatures, like they have to write that all out. So, I mean, the good thing is that if you're on the seller side, you're not signing loan documents, so it doesn't, it's not a ton of signatures, but it is that. So that's good. That's a very good question.
Reese, I just dropped a document in the chat that you should be able to download. It's from one of my closing attorneys. It's a cheat sheet on how to sign documents.
Oh, cool. All right. So the inventory, like I said, the inventory really needs to focus on bank accounts, stocks, large ticket items, things like that. If they have a Babe Ruth authenticated signed baseball, then that's going to need to be, appraised and kept track of and all that stuff. And if they do, here's the thing too. If an estate has a ton of debts and like the biggest asset is this like Babe Ruth signed authenticated baseball, the state could force them to sell that to pay for the debts. So, or they have to come up with some other way of paying the debts if they want to keep that. So family heirlooms aren't always safe, especially if they're a higher value like that. Professional appraisal. So we as real estate agents can do a typical like listing CMA, and we can put a value on the home. And then of course there's typically an appraisal during the sale process. And they just don't want you listing for they don't want the county doesn't want you listing over price, so it sits on the market and the heirs never get their money, and they don't want you undervaluing the property just to get rid of it. So, but that's not really. I've never run into a hassle. No one's ever given me any grief from the county about what we list at, and it doesn't have to be approved. Typically, in most cases, it doesn't have to be approved. I'm trying to think of when it would be, but there might be some legal things happening or liens on the home where the county would have to approve the sale basically, or what you're listing for.
We had to have an appraisal done upon the death because they had owned it for so long, to avoid like the crazy amount of like taxes and everything like that. So we just went through that.
Yeah.
And that's what we used what we're going to use to list it.
And it's probably were you forced? They
told her, they said the attorney told her you need to get it appraised because he's owned it for like 35 years and you're going to be hit with one hellacious, like he bought it for 15,000 and now it's worth, 500. You're going to get hit with huge taxes. You need to get that done prior.
Gotcha.
So we ended up doing that, but I just did think that was a little odd because I was like, what do they care? I mean, I guess they got to know.
Yeah, I'd have to know more about this situation, but there is, as a side note, I don't know if this relates to this or not. There is like inheritance is not taxed until it hits like a certain level where it's like, we're talking like, Warren Buffett kind of money when there's a tax that the government puts on the inheritance. So it's not really qualified as capital gains because you didn't make an investment.
And that's what I was like, that doesn't, like I didn't want to argue with the attorney because obviously I'm not an attorney, but I was like, why won't we just have the buyer do it? And then that saves us all the.
Yeah.
Saves the poor people that just lost their father
Right.
$600 or whatever for an appraisal.
Mm-hmm. What did you say,
I will
Josh?
say, yeah, you were saying that it's like Warren Buffett level, but for someone that's in probate, that has done just 3 reasonably good transactions, will hit that. What is it? There's the gift tax or the probate. It sounds like a lot to us
Mm-hmm.
in our stage of life, but like it's like without sharing personal details at this conversation came up at Tripoli with a
Mm-hmm.
group of people that I was discussing, and there are 9 people that meet at IHOP just within that meeting that will get hit with that because the way that it's calculated affects more people than you would realize. So I say
Yeah.
all that to say I would just encourage to definitely check that. And
Yes.
you wouldn't know it because these are dudes that wear Hawaiian shirts and shorts.
Yeah. No, absolutely. It's for most of the probate that I've come across and run into, or that I think is agents in general. It's a family with the parents. They're selling the parents' home. If that's a good, I'm glad you brought that up though, Jess. If they do have several properties, or they do have very large assets in other areas, then yeah, the tax conversation should definitely need to come up. And honestly, you want to talk with a CPA that is familiar with inheritance and probate and whatnot, rather than an attorney. Attorney's going to have, or the CPA is going to have more insight on actually how that works and how that operates. The attorney really should stay in their lane when it comes to taxes. The CPA stays in their lane, and we stay in our lane. We all work together as a team. That's the best way. That's the best way I've found to do that, because I've definitely had attorneys that I haven't worked with in the past that have kind of given advice on the sale of the home that's not necessarily correct. And just because they might be in or around real estate doesn't mean that they are the best person to give advice on selling the real estate. Any questions? Good. Okay. Do we do that one? Yeah. Okay. Okay. Selling real property. So this is just kind of, I don't want to say repetitive, but just kind of the steps here. Obtaining the court authorization is important. So once you get the letters testamentary or letters of administration, then it's go time. You can get it listed. The things that you can do before that, though, especially if it's a will with everybody knows who the executor is going to be, you can actually get the house prepared, guide them on what repairs may be advisable to do to get done, get the home ready, get a coming soon listing going. You can do all of that stuff. Technically, they if you ask an attorney, they're going to say not until after they're approved, after they get the letters of testamentary. But at the end of the day, if they want to get the things rolling, it's such a process. Most families are appreciative if you get the ball rolling before they can actually have the ability to sign the paperwork. That being said, I always put it in the listing that it's estate owned. Always put it, let the other agents know that are going to see the property, especially the ones that are going to make offers on the property. V Moore. I don't know what your first name is, but V, what's your question?
Yes, I'm sorry, it's Valerie.
Hi, Valerie.
So, hi, I'm not sure if you're seeing my questions in the chat.
Oh, I haven't seen the chat. I apologize. I can't see it with my slides up, but if
Oh,
go ahead and ask it
okay.
out loud if you want, if you're okay with that.
Yes. So in the listing agreement, should it be listed as a probate listing or an estate listing?
That's a very good question. So it's not necessary to do anything different other than what we talked about before, as far as like the signature and the name of it's basically an entity that's selling the property. The estate is the entity, and then the executor is the person, kind of like the CEO of the entity. So that's really the only thing different. I do know I think there's a spot in there where it's like, is this a bankruptcy? Is this a divorce and things like that? It's not really a special circumstance, because once they either have the approval to sell it or they don't. Usually there's not any like court directives about what needs to be done and who has to pay for what for the going through that process. Does that make sense?
It does.
Okay. Yeah.
Thank
I
you.
just fill out my listing agreements like a regular listing agreement, really.
Okay.
Mhm.
Thank you.
Yep. And then I do, like I said, I make sure that in the seller's disclosure, I typically do like the latent defects. I don't do the full seller's disclosure because they 99 times out of 100, they haven't lived in the home. So I just disclose on there, like it's an estate, especially if you haven't got letters testamentary yet. If you haven't got the approval to sell yet, you want to make sure that whoever's making the offer absolutely knows that the closing date could be a moving target, and they just have to have a little patience when it comes to all that, because there's always some things kind of come up. More things come up during a probate transaction that they're not really hard, but if you're not expecting them, they can kind of derail you. So just make the communication is the absolute key, like with anything. All right,
Thank
cool.
you.
You're welcome. This is all stuff. So this is where we start doing our regular job. Like it's kind of no different when we go to the listing appointment. We just need to be a little more empathetic to their emotions. Emotions run high. Sometimes they're 4 siblings are there. There's always one that's kind of off the rails and is trying to bring drama. I'm just going to be honest with you. There's always one sibling that is like they inject the drama, and it's always a much harder process because of their emotional needs. But everybody grieves differently, so you just can't really let it affect you. You just have to roll with it and just be there for the executor. Do the best you can with all the siblings and all the different dynamics and personalities, and you should be good to go. So prepare the property, list and market, and all that stuff. So there's really not any questions about this slide. Okay, let's move on. We're almost done. And then so here's the thing here. So why the house needs to be sold? Like oftentimes there's a mortgage, there's unpaid debts, burial expenses, taxes. It's now when we say taxes too, that like inheritance isn't taxed until a certain point. And I apologize, I should have looked up the number. There is a definitive amount that if it's over that, it gets taxed. But property taxes, however, if there's liens or if there's property taxes that have not been paid, that absolutely has to be paid from the sale. And also, most of the time, the deceased still has to file their taxes. So the executor has to file their last year's taxes. And that has to be paid as well. So that's just that was kind of it took me a minute to get my head around that when I started this, but I guess it makes sense. They were, while they were alive, they have to do their last set of taxes, post-mortem there, which is kind of funny. I mean, not funny, but all right. Valerie, your hand is still up. Did you have another question, or I just want to make sure?
No,
Okay.
no questions. I need to
Okay.
take that down. Thank
Okay,
you.
cool. Oh, you're good. I don't want to skip over if you had something there.
Thank you. Nope.
Okay, so agent opportunity. So this is like, how do we get these leads? I'm going to spend a little bit of time on that and not a whole lot of time, because it's more of. Let me back up a little bit. So if you have to have a servant heart, you have to be a special kind of person to have the patience. Like if you're not a patient person, this is not the niche for you. Absolutely. If you have a hard time showing empathy, this is not the niche for you either. And you have to be really good at managing people in a way that are going through a really rough time, emotionally charged. Like emotions are like roller coasters, because you not only have the stress of the loved one and the grief, but you have the stress of selling a property. And we all know, like regular clients, that can be tough to handle also. So just all that, I think, is the most important thing that we have to do. And just do your job and give them the guidance and have a lot of communication is the key. So for driving business to you, there's a couple ways you can do it. I tried a few things. I bought lists. There are companies where you can just get a list, and oftentimes it'll have the deceased, the address, the executor, their email address, phone number, and if there's an attorney, they'll have their address and phone number as well. That's a typical list for probate list. There are companies, and I'm going to give you one of each of these that I've used in the past. I'm not endorsing them, but I've used them, and there's nothing wrong with them. It just depends on what kind of service you're looking for. The other company, and there are several companies out there that will do, they not only give you a list, they give you kind of a CRM to go through and organize your leads that come through. It's very basic CRM, and then they'll have like marketing material for you. They'll even like do mailers for you. It's usually in addition to the cost that you're spending for the leads, that they'll do mailers on a regular basis for you. They'll have they just have a lot more service and a lot more resources and marketing, and they meet every week or so to go over things and give you guidance. You can ask questions and all that stuff. So let me see if I can throw that in the chat. Let me get through my slides and I'll put that in the chat. So remind me to get back to that. Also, the cash advance programs. There are companies out there that specifically loan to estates so that they can, get the ball rolling on things. And then, once the house sells, then they get paid. It's technically not a loan, but it is a loan, and they'll usually charge it's $3,000 for X amount of money, or it's $5,000 for X amount of money for X amount of time. It's not really they're not charging like a percentage rate often. It's more of like a flat fee for how much you need and how long you need it. But there are companies out there. I don't have one to recommend. I've never had to use one, but I have offered that to people. And I know they're out there. I know that I'd find just make sure if you're going to recommend a company like that, do your own vetting of the company. Because with everything else, there's better, more ethical companies out there than others. If I think of it, I'll put it in an email. The email I send out next Monday, I'll put it in the email if I remember. So go from there. Okay, cool. And then, so yeah, just some common challenges. Like oftentimes, like I said before, there's liens and title issues that come up that no one knew about. Family disputes are a real thing. I've found on several occasions that one of the siblings, it tends to be the youngest one. I don't know why. I'm the youngest of my family, so maybe it's the youngest, just the way we are. But they have this underlying hope that the rest of the siblings will just give them the house, let them live in it. I don't know where it comes from or why they think that that's a thing, but I see it. It's quite common. And so they'll do little things to kind of sabotage the progress because they're hoping that they can somehow keep the house for themselves, if that makes sense. So that's just one dispute among heirs. It's always, they might dispute on when you get offers. They'll dispute on what they're going to accept as an offer. Usually there's one that just wants to unload it. They don't care. And there's another one that is like, we need top dollar. The house is worth way more than that. Mom and dad took great care of the house. And they kind of hold out for, that high price. So it's kind of like when you're dealing, we've all dealt with sellers, and some of the sellers have different personalities. You're kind of dealing with multiple seller personalities all at the same time when you're doing probate. You just have to remember that it is the executor that is the decision maker and the most important. And don't make the mistake. I did this when I first started doing this, and I regretted it, and I don't ever do it again. Is I explained to everybody in the listing appointment, everybody that's there, I say, listen, I'm available for questions whenever you want. You can call me if I don't answer. Leave a message. I'll call you back. Send me an email, whatever. I said, but I'm just going to communicate with one person. I'm just going to communicate with the seller or the executor. That's if I try to it gets too messy and gets delayed and things get missed, I'm going to communicate with the executor, and then they're going to communicate to the family. Like that's part of what they do. So make sure that you don't, because I was putting everybody on emails, and my gosh, if I presented an offer once to a family, and it wasn't it was not a good outcome. They never got under contract with that offer. And that's when I really learned, like, I just need to send to one person. So, just a little tidbit of advice for you. Deferred maintenance. This is just kind of stuff that we see, with any listing. Emotional attachment, of course. Court approval delays. It can take from start to finish. I would plan on 6 months to a year from your first contact, from like your listing appointment until they're ready to go. Now, yes, there will be times where somebody's ready and a month later you're listed and getting offers in. But typically it's between 6 months to a year before you actually go onto the market. So keep that in mind. And every single family, when I tell them that, they're like, "Oh no, we're gonna do it faster than that. That's ridiculous. We're not." And then it typically ends up being 6 to a year, 6 months to a year. And they always say, "Man, I didn't believe you when you said that, but I guess you were right." So, right. And then here's the opportunity here. There's 2.5 million plus probates annually in the United States. 40 to 60 of them have property to sell, real estate to sell. And what's the other one? Six to eight. Yeah. It takes 6 to 18 months to build trust. We know that already with other leads. So there's a huge opportunity here. And then what we're in right now is where boomers are passing. Boomers is one of the biggest groups of people. They're getting to the point where they're passing, and most of them have homes, and like I said, 60% of them have homes. So there's a good opportunity there. So I'm going to kill the sharing, and I'm going to put some links in. I'm going to put some links in the chat. Oh, there's all the chat. Look at all that. So for what I just put in the chat, the first link is to a company called List Central. You may have heard of it. They do absentee owner lists. They do people that have been in the home for 7 years or more lists. They do all sorts of real estate leads lists. Probate leads I think they're $0.25 a piece. So 25 cents a piece. You get all the leads you want. That's it though. You just get the list. It's a CVS file or a Excel document, and you got to go through and sort through and make the calls and do all the stuff on your own, which is good. If you're inclined to do that, you already have marketing in place, that's perfect. All the leads is the complete opposite of that. They give you leads. It's very curated. They have marketing. They have letters, mailing examples from like the first letter to attorney letters to all sorts of letters, and all sorts of marketing and all sorts of like posts and things like that. That you can, it's like a full service, essentially. They are much more expensive. When I had them, I had their website as well. I think it was about $330 a month. Between the website, I think was like $40 on top of getting the leads and all the service that they had. So it's a difference. 25 cents a lead as opposed to, 300 a month. And I only got about, for Fayette County, from all the leads, I only got about 40 to 50 leads a month. And some of them were better than others, we'll put it that way. They really can't control the quality of the leads because it just comes from the public records, which is another thing you could do. You could go to the courthouse or allege a lot of the counties are online. You can go and pull lists yourself. That's a little harder. It takes a lot of time. I'd rather be, going on appointments than pulling lists from the courthouse. And then one thing I didn't mention is I would send letters to attorneys. So I'd get these lists and I'd see the attorneys on there. Their addresses are in there, their mailing addresses. So I would send letters to them. And so I've included a link here. And if you're watching on YouTube, the replay, just send an email to b@thereagent.com. Put the subject line attorney letter, and I'll make sure to send you one. But it's in there if you wanted to pull that and check it out. It's editable. It's a doc. So I think it's a Google Doc. So you can edit it and change it, put your website in there and all that stuff. I wouldn't change the wording up all that much because it's been through a couple edits to try to really be the most effective. But you can do whatever you want with it. It's yours now. Cool. All right. Let's open it up to questions. Let me turn the recording off. So if you're watching the replay, make sure to go and register at the reagenthive.com to get on the live, and you can be part of the Q&A. See you then. All right. Stop recording.